a police chief watched someone get dragged into a van and said, "I'm not in a position to decide if that's illegal," would you call that caution or collapse? Because that is exactly what unfolded when Jeff Merkley questioned Kash Patel. This is not a normal hearing. This is a stress test of whether the Constitution still has enforcement or just language. The room expected a budget debate, numbers, routine oversight, the kind of procedural exchange that fills time but changes nothing. But Jeff Merkley didn't start with money. He started with the Fifth Amendment, the line that says no person can be stripped of liberty without due process. And then he introduced the reality. Hundreds of individuals taken off the streets, removed from the country, without a court hearing. So Merkley asked the simplest question possible. Does that concern you? Kash Patel didn't say yes. He didn't say no. He said, I'm not in a position to comment. And in that moment, the hearing stopped being about policy and became something else entirely. Because when the person responsible for enforcing the law steps back from the question of whether the law was broken, you are no longer debating facts. You are watching responsibility being declined. And Jeff Merkley doesn't let that space empty. He tightens the question, removes every escape route, and brings it back to action. Have you launched an investigation into a violation of the Fifth Amendment? That's not abstract. That's not philosophical. That is the job description. Kash Patel pauses, then shifts again, not toward an answer, but toward distance. I don't know that I agree with your characterization. Listen carefully to what just happened. The question was about whether a constitutional violation should be investigated. The response reframed it into whether the some description of that violation is acceptable. That is not clarification, that is deflection. So Merkley strips it down even further. He doesn't cite theory, he doesn't argue interpretation. He goes straight to the text. The Fifth Amendment says no person, not no citizen, not no legal resident, no person. And yet, in this exchange, Kash Patel repeatedly avoids affirming whether those protections apply in the situation being described. He says he agrees with the Constitution. He says he supports it fully, but when asked to connect that agreement to a specific act, an investigation, he steps back again. It's not for me to call the balls and strikes. Now the contradiction is no longer subtle. Because if the director of the FBI does not determine when the law may have been violated, then who does? And more importantly, what happens in the time between the violation and the decision to even recognize it? That gap between what is written and what is enforced is where systems quietly fail. And Jeff Merkley drives directly into it. He doesn't raise his voice, he doesn't dramatize, he simply stacks the facts in a way that leaves no room to hide. You are aware the Fifth Amendment applies to all persons in the United States? Kash Patel answers yes. But when Merkley connects that principle to the real-world consequence, people detained and removed, deprived of liberty, Patel retreats again into classification. That is a constitutional question. No, that is a legal trigger. Because the moment liberty is taken, due process is no longer optional, it is required. And this is where the record becomes unavoidable. The Fifth Amendment, ratified in 1791, does not leave ambiguity in its language. No person shall be deprived of life, liberty, or property without due process of law. The Supreme Court has reinforced this repeatedly. In Miranda v. Arizona, the court affirmed procedural protections apply broadly to individuals under government custody. In Reno v. Flores, the court reiterated that non-citizens are still entitled to due process protections under the Constitution. This is not unsettled law. This is established doctrine. And yet, sitting in that chair, Kash Patel introduces a new threshold. Not written in any statute, not found in any ruling. He suggests that unless the Supreme Court has directly adjudicated this exact situation, he is not prepared to act. Think about that standard. If law enforcement waits for a final Supreme Court ruling before investigating a potential violation, then no investigation begins until after the system has already failed. That is not enforcement. That is delay dressed as caution. Merkley sees it, and he pushes harder. He reminds Patel of something fundamental. Not legal, but ethical. You took an oath to the Constitution. And Patel responds almost defensively, "Thank you for the reminder." But that exchange reveals something deeper than disagreement. It reveals a fracture between acknowledgement and responsibility. Because agreeing with the Constitution in principle means nothing if, in practice, you refuse to act when it may have been violated. Now the contradiction is fully exposed. Kash Patel claims the FBI investigates violations of law. He acknowledges the Constitution as the highest law, but when presented with a scenario that may violate that law, he declines to determine whether it meets the threshold for investigation. That is not neutrality. That is selective engagement, and here is where the stakes shift from legal theory to lived reality. Because this is no longer about a hearing room, or a line of questioning, or even two individuals in conflict. This is about what happens to people when process is removed. A person detained without explanation. A person transported without a hearing. A person removed without standing before a court. No lawyer, no judge, no moment to speak. Liberty, taken, not by verdict, but by procedure. And if that action does not immediately trigger scrutiny from the very agency tasked with enforcing the law, then the question is no longer whether the Constitution was violated. The question is whether anyone in power is willing to say so. And this is where the hearing stops being about Kash Patel or Jeff Merkley, because the real subject is you. If the Constitution says no person, but enforcement depends on whether someone in power feels ready to act, then your rights are no longer guaranteed. They are conditional. Conditional on interpretation. Conditional on timing. Conditional on whether someone decides the situation is clear enough to matter. Imagine being taken off the street, placed into custody, moved across borders, and never standing before a judge. Not because a court ruled against you, but because the process never began. That is not a technical failure. That is a moral one. And when the official responsible for investigating violations responds with distance instead of action, what you are witnessing is not caution, it is permission. Permission for delay. Permission for ambiguity. Permission for the law to become optional in the exact moment it is needed most. This is not about party. This is not about policy. This is about whether the rule of law is applied evenly or selectively, depending on who is affected. Because if due process can be set aside for one group today, there is no structural barrier preventing it from being set aside for another tomorrow. So here is the question that remains. When the Constitution is clear and the facts are in front of us and the authority exists to act, what does it mean when the answer is still hesitation? If moments like this matter to you, don't just watch, engage. Like the video, share it, subscribe. And tell me in the comments, is "I'm not in a position to comment" a responsible answer or the beginning of something much harder to reverse?